Hello there, and welcome to yet another episode of Know Your Laws, where we talk on matters to do with law, justice, and legal affairs to help you understand what the law talks about in this particular country. And today we are going to have a discussion and help you to learn about marriage and the laws that govern marriage here in Kenya. And to help me discuss that, to have that discussion, is my guest, who is an advocate of the High Court of Kenya, and that is Kevin Doho. Welcome to the program, Kevin.
Thank you so much.
And it's so privileged to have you in this particular program. And just to get started in our discussion, because I've introduced you officially, my first question to you will be, there is what people talk about marriage, but people don't understand that there is a definition of marriage. So let's begin at this point where we define, under the law, what is marriage?
Marriage, under the laws, is the union of a man and a woman for life. That is the old definition of marriage, as we got it from the colonialists. But it was also the union of a man maybe to several women, according to various customary laws that we have in Kenya, basically based on the number or the tribes we have in Kenya and how those tribes define what is marriage. For the Quran, it has its own definition, that's a Muslim marriage. The Hindus, they have their own definition of marriage, and that is marriage also. But ideally, a Christian setup where we are in the Commonwealth of Nations under the United Kingdom, the definition of marriage is the union of a man and a woman for life. Yes.
And now, having now understood what marriage is, coming back now to Kenya, of course, we have different religions. We have Muslim, we have the traditional way of life, and we also have the Christian way of life.
Yes.
What does the law recognize as marriage?
For the various parts of the various types of marriages, each type of marriage has its own laws. So for us here in Kenya, we usually do not have other types of marriage, for example, gay marriage or various, you can have a woman trying to marry many men. That's not something that is recognized in Kenya. But for each one, there is a definition. For statutory marriage, it is a union of a man and a wife for life. For traditional marriage, it's a union of a man, maybe to one wife or to several wives, according to the customs of that tradition. If it's Hindu marriage, they have their own setup. If it is Muslims, it's the union of a man to a woman for life, but the man is allowed up to four wives. So that union is for life. It does not, you cannot have it after death. So we have not yet been able to define that relationship after death, but we have other types of marriage that are outside the law. So we are in a state of flux. We had a review of our laws. 2014, we have now one marriage act. Before that, we had several marriage acts, like the Marriage Act, the African Christian Marriage Act. We had the Hindu Marriage Act, the Mohammedan Marriage Act. We had the cultural ones were not codified really. They were just recognized as customary marriages. So we were trying to bring it together since 1978, when the report was first given. 77, when the first report was given to the first president, Jomo Kenyatta. He was given two reports, one for the law of succession and one for the law of marriage. The one which passed and was prorogued up to 1983 was the Succession Act. But for the law of marriage, for the longest time, it took so many years, up to 2014, for us to pass it, but it had a lot of contentions. And some of those things are what we see in our society, in the news today. Mm-hmm. Yes. And
now, talking about the law that has been governing the marriage right here in Kenya, of course, you've broken out the Marriage Act of 2014. You talked about presumption of marriage. For our viewer who is viewing right now and has heard of the different types of marriage, of course, the Hindu, Christian, Muslim, and then there is what you mentioned as presumption of marriage. What is presumption of marriage?
Presumption of marriage has three elements: cohabitation, well-known, and they behave as husband and wife, in such a way that society has accepted this is this person's husband, this is this person's wife. They live in the same house, they have children, they basically go everywhere together, they do things together. It's what society has already established. It is not something that is backed up by any paper or any ceremony or anything. So for example, if, for example, you move from here, maybe you go to live in London, basically you'll be going there with your wife. So those people will be looking at you and saying, this is Mr. Macharia and this is Mrs. Macharia. They don't need to see your marriage certificate. And that kind of society where people just accept is this is this person's wife and this is this person's husband, that is presumption. However, the problem that the law has with the presumption is when there is a dispute. For example, the husband dies and leaves property. And basically there is a dispute between the wife who the man married in church and this other wife whom nobody knows. So you find the law has tried to create a solution by saying, yes, you married under the Marriage Act at that time, which prohibited a man from marrying another woman. But this man left this wife of his who he married under the Marriage Act, and for over 30, 40 years he's been living with this other woman, had other children. So it will be unjust to say that they were not married. So that is now presumption. So the court will now presume there is marriage and now divide the property accordingly. Other types of disputes might be involve, for example, you leave behind property after you die, but the wife cannot produce a marriage certificate to the lands office to be able to transfer the asset to herself. So she'll go for a court order, and the transfer or the succession will follow according to the laws of presumption. Presumption is outside the law, it's outside statute. It's not something that you can, it's tangible. It's something that is based on facts, the facts of that person's life. How did he live it? Who did he live it with? How long did they live together? What did society really think about them? So it's unfair for somebody maybe to die and then the property is shits to the government, or it's considered abandoned property. So that is one of the reasons we have presumption of marriage.
And now, having defined the presumption of marriage and all its formalities, can we say a presumption of marriage can create a marriage?
These things basically are presumed. In other systems of law, like in Italy or in England, they're called common law wife, a common law husband. These are husband and wife according to the law of the land, or according to how the judge in England says this is marriage. So, for example, you might find a case where the judge says if you live together for 5, 6 years and you have kids, you had property together, you basically lived your lives together, the judge says you people are husband and wife. And from that presumption, from that announcement or pronouncement by the judge, that becomes case law. When it becomes case law, it becomes law. So it's not something that is codified by Parliament, although they should consider codifying it. Unfortunately, when they were passing the Marriage Act 2014, that argument came round and they said every type of marriage has to be registered. If you don't have a marriage certificate under the Kenyan law, according to how they passed it, you're not really married. So you find the conflict between Parliament and the judiciary at that point. Because the judiciary is saying, or the judges are saying, there is something called presumption of marriage. When they were passing the Marriage Act, they said, we don't want the presumption because a man dies, we only know of maybe 2 or 3 wives. Then when he dies, somebody else comes from nowhere and starts saying they were a wife. Then that dispute cannot be resolved because this is a stranger. So to remove that, they said even customary marriage, you have to get a certificate from the Registrar of Marriages. So we have that conflict between the written law and the law that is made by the judges. So you might have problems when you're interpreting that type of situation. You might find in one case, one judge says this is marriage. In a famous case, you might find there was this case that was determined where a woman had 5 children with a man, and the judge said there was no marriage. They had lived all their lives together. They were able to sire children. Everybody, even the community, knew they were husband and wife. But the judge said, no, if you don't have a certificate of marriage, there's no marriage, even if you have 5 children. So you see that type of controversy that was brought in by the Marriage Act 2014 leads to a lot of injustice because you do not understand the predictability of what is happening. If you want to be responsible, go to church, get married, get your certificate. If you're already married, go to the registrar of marriages with an affidavit from a lawyer and prepared or signed by the elders in your community and get a certificate of customary marriage. If you are a Muslim, go to the mosque, go get your certificate. Because the way the law has moved, it has created a lot of unpredictability on, are you married or are you not? As far as the law is written, if you don't have a marriage certificate, you'll have a lot of problems in the future.
And now as we stay again on the presumption of marriage, of course, that is the most common aspect in the society. Of course, people living together, but they don't have that certificate of marriage. So in this particular case, because as commonly, that is that you come, we stay together for long, and then we presume that we are married. So come we stay, or rather the formality of come we stay together for long, at any point, can the law recognize that as sort of marriage?
Yeah, come we stay is recognized as marriage presumptively. But because of the change of law in the Marriage Act 2014, if you don't get a certificate within 3 years, that was, the deadline was 2017. If you didn't get a certificate by 2017, the law, as Parliament has written it, you're not really married. So you are gambling. Well, if you ever go to court, for example, for the property of the husband, and the judge says, you guys were not married, you didn't come with a marriage certificate, you're done. But if you find a judge who's able to understand the social mores and the way people live in our society, then you might find yourself being presumed a wife. So what I'm trying to say is, people are supposed to take responsibility for their lives. They shouldn't leave it to a judge to try and tease out whether you are married or not. It's like pata potea. And the reason I'm saying this, it's that it's an old argument. It's a very old argument. In traditional Europe, you find a person who elopes, for example, elopement. Maybe they come from like a Romeo and Juliet, the house of Capulet and Montague. You find, because those two houses are fighting, you find the children will just elope, go get married and live somewhere away from Verona, maybe in Venice. In various cultures, we had marriage by capture, where you go, you kill the men, then you take the women and children and the daughters as the wives. It's as old as the Bible. It's something that has been there. But society has always looked frowned upon it. So, for example, when the person who has taken maybe a woman away from the family, when the other brothers and the father find that woman and the husband, they will ask for blood or for recompense, which could be called weregild. So it was frowned upon. Even to this day, you find people have been doing that when they go to their parents, to their cultures, to their shago, they pay something called a fine. The same thing that the Europeans used to call as a weregild or as a recompense. Here we call it a fine. You took our daughter, you lived with her, you had children. For each child, there is this fine. You should have come before you got married. So there is some social and cultural reluctance to come with their marriages. But from the way the law is written right now, it's so uncertain. You have to really just take charge, go get married. If you can't get married under culture, come to your lawyer's office. He'll advise you to go to the ages. You just pay up and sign and have only 2 witnesses and you're done. If you are basically a Muslim, you go to the mosque, you're advised and you do it. You go to a Hindu temple, you go to a church, you'll be advised and you'll be able to go through it. The problem is that people live their lives and they have the freedom to live their lives. You can't dictate order. You can only provide people with options, especially on things like love and family. Those are some of the most sensitive things for humanity.
Of course, there is a direct definition of what Kenyan law recognizes marriage as. But again, of course, it's something that is very common in the society, and it's not something that we can run away from, whereby people believe that living together for long constitutes to the common law of marriage. How applicable is that in the dispensation of the Kenyan law?
So it's clear. Common law marriages are usually just presumed by the courts because of justice and the facts of a case. The judge listens to this, says, these people, I think I can presume them or they were married. Maybe the marriage certificate got lost, maybe the ceremony was the cultural ceremony was performed so long ago there was no one who's alive to come and swear affidavits to have the marriage registered, things like that. So sometimes the law is very difficult, but you have judges now to interpret the law.
So now, for instance, right now, somebody has presumed themselves as married in a certain marriage setup, and now here comes a point where now there is a sharing, assuming now both of them are alive, but now there's that form of dispute between the two of them. At this point, they never went for the recognized marriages here in Kenya, but the two of them have been living as husband and wife under the presumption of marriage, but now it's time they have a dispute. So in such a case, how will the law now intervene in between the two?
That one is very difficult. It's very difficult because you are not married. Presumption of marriage usually arises on issues of succession, where one of the parties is not alive. So the judges try and presume marriage so that the wife, the one who was left behind, can get something out of the estate of the deceased. For issues to do with unmarried people just living together and presuming themselves to be married, they will not find any protection under the marriage laws. They might find protection under other laws. For example, if there were any contributions made, maybe they can claim ownership of some of the assets. The contributions can be presumed to be monetary or other things, but there is nothing that you can file under the Marriage Act for people who are in Cambodia. It's a very precarious circumstance for somebody to live under, and it's not encouraged. And because it's not encouraged, it's not in the best interest of the common good. You will find no protection when both of you are alive. You might find some protection when one of you is dead and you want the property of the person who's dead. But for issues to do with presumption on marriage and disputes between persons who are not married under the law, there's no jurisdiction to determine it under the marriage laws. Maybe we might determine it under law of contract, for example, or the land laws if there was some trust that was created, things like that. Trust is where maybe somebody buys property, but you say he bought that property for me and the children, as if that's a wife. So he held that property as in trust, but you can't find that under the law of marriage because you're not married. Mm-hmm. Yes.
Because right now, from hearing from what you speak, is that the law on marriage is very definite and very complete. It does not compromise itself when it comes to its dispensation. What does the law, rather the courts, look at while determining a dispute resolution in a marriage setup? For instance, in inheritance of a wife that was married. And now here comes a dispute where probably the family of the deceased say she was not married to the man. Now, what does the court now look to settle such a dispute?
You see, there's one big law called family law. Family law has three areas. It has the law of marriage, the law of death, that is probate and succession, and the law of children. That is family law. So if you are alive and there's a dispute, for example, divorce and maintenance of a wife and things like that, you'll look at the Marriage Act. Once one of the parties is dead, you move to the other law. That is the law of succession. Now, under the law of succession, it is very unique. It is nearly an enclosed code. It sits outside marriage, and it operates, it moves with death. So you'll find yourself in a very special code outside the Marriage Act. Now that code was codified in 1983, where it has various methods of determining a dispute between the people whom maybe a man has left behind. So it says the first dependents are a wife or a former wife. That is what it says. So for example, if you had a wife, you divorced, and then you die, having married another one, your former wife will have the right to inherit from you. That is the law of succession. However, the law of succession says if you had been given a gift during the lifetime of the deceased, it will be taken into account when the judge is distributing the property. So if you got a divorce and you got a settlement, for example, you are given some land somewhere, no issue huko, ni nyumba yako nimekujengia, you stay there, that gift will be taken into account when distributing the property if it's a former wife. So if there is other people who are saying they are dependent, they have to prove it. Because the two people who have a right to inherit is a wife and a child. Any other person, you can't come in unless you prove dependency. So for example, if you are, the parents were being supported by the man when he was alive, they'll come and produce evidence that he was supporting them, and they are truly dependent. But it's very difficult for you to inherit from an estate of a deceased if you're not a child or a bona fide wife. Now, where you had a come-we-stay marriage, and basically you had lived for a long time, you'll come and tell the court to presume marriage. And the court will now look at the elements of presumption of marriage. Long cohabitation, well-known, there were issues or children from that, or there was evidence to suggest that you are husband and wife. Then the law can presume you to be a wife and give you rights to inherit from the deceased. Now, when you come now to children, now that is a different issue. Children will always have a right to inherit. Now, who's a child? Now you move to the final area of family law. That is it. So those ones, no one can disinherit, whether they like it or not. And actually, they are the ones whom are supposed to inherit, because as the way life goes, one generation goes and the next one comes up. However, if you marry a woman who has another child, basically you just took that woman in when she has a child. Now, unless you took responsibility for that child as a parent, as a father, that child will not have a right to inherit. You basically owe no obligation to that child. But if you live with that woman for more than a year in the same house and you took over parental responsibilities, then it can be presumed, unless the father of the child is still there. That means the law will presume an orphan whom you live with to be your child. But if that child has a father and the father is out there, the court will always hold that father responsible. It will not let him off the hook just because the woman got another husband. So that is now the law of children. And for that child to inherit, he will not inherit in that house where the wife has, the woman has married the second husband. He will inherit from the wife, from that mother, and from his biological father. Because you can't have two fathers at the same time. You can't have two mothers at the same time.
And still staying on that particular law of marriage, under such circumstances, here comes a situation where a man is married to his wife, a current wife, and then there is an ex-wife, or rather a former wife, whom they didn't divorce legally. But now, there is now a conflict. Can the first wife who was divorced, or was not divorced legally, claim to be part of the marriage?
You see, the history of marriage is, especially for the English marriage, a statutory marriage is, you can't marry twice unless you're divorced. You first divorce, then you marry. If you marry two women at the same time, it's a crime called bigamy. Bigamy is basically marrying too many women. It was a social construct from England where the social construct was you only have one wife. That was the law of the church, the law of the Church of England, and that was Catholic law. I think it still is. But now we have the African customary law, we have the Muslim law, and it comes into conflict. Now, the judges have tried to to understand when the borrowed law, the colonial law, or the English law, or the statutory law collides with the customary law, which one wins? So if you have a former wife, you didn't divorce, and you have married another one, how did you marry that other wife? Did you marry that other wife under custom, which is allowed, or did you try and marry her under statutory marriage, which is not allowed? That's why we have a register of marriage. One of those requirements of marriage, you must declare that you don't have any other wife. So by the time you're divorcing, if you make that statement, it's true. But you cannot come there and say you don't have any other wife when you have not yet divorced. That's why you find sometimes in the marriage certificates, you find the man's name is bachelor, then the woman's name, then spinster. Now, in the old law, if the man is divorced, you'll say the man, then divorced, not bachelor. So you find even many job forms, you'll say, are you single? Are you married? Are you divorced? Most people just put in married or single. No one wants to put in divorced. Because in the history of societies, a divorced person is
perceived in a certain way.
Not only perceived. In the long time ago, they had certain disabilities. They could not do certain things. They did not have certain rights. They had various historical prohibitions. Then they were taken away in, I think, the Marriage Act for England, 1925. For us, divorce is something very bad, but it's allowed. The customary ways have their reasons for divorce. It's not only infidelity. Sometimes it was witchcraft. Sometimes it was bad luck. Sometimes it was something weird. But in Christian society, we try to do away with divorce. What we have is annulment. So basically, you come to court and you say, there couldn't be any marriage because by the time I was getting married, this person was not mentally competent to marry. So there was a presumption that there was no marriage to begin with. Instead of saying there was a divorce, there is a divorce now. Divorce presumes there was a valid marriage. Annulment means there was no marriage.
There is that presumption of marriage and the legality of the marriage. From where you sit, how do you put your parting shot in regards to the law on marriage here in Kenya for our viewer who is viewing?
The law of marriage has tried to be, the parliament has tried to codify the law of marriage. If you're married under the church, you get a certificate. If you're married under the ages, you get a certificate. If you're married under custom, go get the chief's letter and affidavits prepared by your lawyer for the wazes to witness that they saw you in the ceremony getting married. Then you take it to the registrar of marriage, gives you a certificate. Now, presumption, there is nothing like that. In the Marriage Act, there is no presumption. Presumption exists outside the Marriage Act, and mostly it exists under the circumstance of the law of succession. So basically, you are in a very unsafe area if you are trying to live under presumption. It's time, as Parliament has said, it's time Kenyans put their house in order. They were given a 3-year deadline from 2014. So the 3 years was lapsing in 2017. From then on, Parliament presumes that every person who's married has a certificate. It's because marriage is also a source of a lot of disputes. To prevent those disputes, just go get married, get a certificate, and make sure you're not relying on presumption, or come we stay. Yes. And
on that particular note, that is where we wind up our discussion about Know Your Laws, where we've been talking on matters to do with law. Thank you so much for making time to help break down this particular big law that people presume it, but again, it is one that is applicable in the most strict way. And thank you for making time for this program. That has been our discussion on Know Your Laws, where we have been talking on matters to do with the law on marriage, breaking it down for you to know whether you should be married legally or there is something else that you can do. Perhaps you may know there is no presumption of marriage in the Kenyan law, but again, that is the technicality of how and what we apply here in Kenya. That has been our program tonight. My name is Chris Sambu. See you in the next episode. Goodbye.